This segment is about the bankruptcy claims process. The bankruptcy concept is that the court, or the trustee appointed by the court, takes the assets available, converts them to cash, and distributes them according to a statutory waterfall, with higher priority claims receiving payment first before lower priority claims. At each level, anyone and everyone who has an interest has the opportunity to challenge who shares and in what amount. A trustee appointed by the court gathers all the claims filed and analyzes each to see if they are timely filed, properly documented, and make sense in the context of this debtor's financial life. For instance, the trustee of a small furniture store in Nashville, Tennessee, should be suspicious of a claim filed for cable TV service for a residence in Des Moines, Iowa. It should lead to an inquiry, if not an objection. The trustee's role at this point is to resolve questions and issues and try to work things out with the claimant directly, or file an objection and ask for a decision by the court. If an objection is filed, the court will set a time for a response and a hearing. If the claimant is far from the court, or the claim is small, it may not be worth the time to respond. That's hard to tell unless there's an indication of what the percentage distribution will be. In summary, whether your claim is worth fighting for is up to you and depends on many factors. But if you get notice of an objection to your claim, pay attention and make a choice. Don't just ignore it and lose by default.
In summary, during the bankruptcy process, assets available for distribution are taken, converted to cash, and distributed to creditors. During the claims process, creditors have the opportunity to challenge who shares the debtor's asset distribution and in what amount. Claims filed with the court are typically analyzed to see if they were timely filed, properly documented, and appear to fit with the debtor's financial life. Trustees act on behalf of the debtor to guarantee that both the creditors and the debtor's interests are maintained in accordance with the Bankruptcy Code. A trustee may file a formal objection against a claim, after which the court will set a time for the creditor to respond and/or attend a hearing. Whether your claim is worth fighting for depends on many factors, but if you get a notice of objection to your claim, be sure to make an educated choice rather than ignoring it and losing by default. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.